So yeah, greetings again. My name is Philip Gray and I am the Vice Chair of the GB region. I'd like to welcome you to tonight's event, which is the final part of the three-part series on NEC contracts, hosted here by the Engineers Ireland GB region. Our speaker is William Brown, who is a qualified civil engineer, solicitor and adjudicator at Fortfield Brown. William is a director at Fortfield Brown, who are a specialist legal firm with expertise in construction law, contract training, and dispute resolution. I'm now going to hand you over to William. Thank you, William.
Thank you very much, Philip. So just going to share my screen with everybody and make sure the IT is working. So standard operating procedure at this point. There we go. So can someone just confirm that you can see the slides and that you can hear and see me okay?
Yeah. Confirm. Yeah.
Good stuff. And again, just to reiterate what Peter says, any questions, folks, feel free to either put them into the chat box. And I don't mind if you want to jump on the microphones as well. That's fine. Just keep them muted whenever you're not asking questions is all I ask. So I recognize quite a lot of people in the audience there. Again, lots of returning names from last week and the week before. So I'm not going to introduce myself. There's my details. If you need them, you can see them at the end as well. So in terms of what we're looking at in this third and final session, we're picking up where we left off last day, looking at the assessment of compensation events first and foremost. And that'll be the biggest chunk of what we're looking at this evening. Where we left off last day was getting compensation events notified. I talked everybody through my little three-part process for dealing with compensation events under the contract. Step one is to identify them. And again, you'll find most of them in one clause of the contract, makes it lovely and easy, clause 60.1. Step two is to notify. Again, dead easy. Where it gets a little bit more complicated, what we looked at last day, is that there's two categories of compensation events effectively. There are compensation events which are triggered by the PM and the supervisor. They are not subject to any notification time bar. And strictly speaking, the PM or the supervisor should notify them at the time that the instruction's given or the certificate's given, whatever it happens to be. So again, not subject to a time bar is the key thing there. All of the other compensation events are to be discovered by the contractor. They're nothing to do with the PM doing anything in a positive sense. And all of those have to be notified by the contractor under 61.3. And as we talked about last day, that has to be done within 8 weeks. If you're dealing with the likes of the subcontract, just to maybe note there is a difference. It's a 7-week time frame. Point being, subcontractor has to notify the contractor within an earlier time frame, so that the main contractor can pass it up. And that's just an example of how some of the contract terms differ slightly depending on where in the supply chain it is. But that's what we talked about last day in quite a lot of depth. What we're looking at this week is part 3 of that exercise, getting to the quotation stage and how do you actually prepare that quotation in terms of the change to the program, the change to the planned completion date, and also the money that goes along with that. And we're going to be opening that up and looking at that with reference to a worked example here this evening. So again, as I say, we'll probably spend half to 3/4 of our time within that particular point. We will then briefly look at the payment mechanism. It's dead easy because when you're dealing with payment in the UK, you have to deal with payment in a very specific way, in a way that complies with the Housing Grants, Construction and Regeneration Act of 1996. That's a piece of law I've talked about a few times. And one of the things that law requires construction contracts to do is have payment terms that look a very special way. And the NEC is no different. Its terms are drafted to comply with the Housing Grants Act. If you use the appropriate secondary option, that is, which is YUK2. If anybody's working in Northern Ireland, there's soon to be a YNI clause, again, which I drafted with the NEC in the next couple of weeks. If you're in the Republic of Ireland, there's an Irish version of that, which I was also involved in. YIR does the same thing. It just updates the payment terms to make it work in those jurisdictions. The penultimate topic then of this course is managing defects. Again, it's rather straightforward as well, to be perfectly honest. Where the NEC is slightly different to most other forms is it specifies a time period in which those defects are to be corrected. We call that the defects correction period, where most other contracts leave that open-ended and they just say you have to correct it within a reasonable time. There's arguments for and against the NEC way of doing it, of having a 2-week window. You know, is the word reasonable better there? In my opinion, it probably is, because the word reasonable and what is reasonable in the circumstances will change depending on the nature of the defect. So if it's an emergency problem, the power is off in the building, you might want it corrected much quicker than 2 weeks. So the word reasonable would imply you get it done right away. Whereas if it's a scuff of paint, you know, it might not be necessarily be something of too much of a problem. 2 weeks would be ample time, and perhaps even a month would be fine. So the word reasonable, you know, there's pros and cons for using that word, but the NEC doesn't use it. It has a time frame. So we'll open that up and we'll look at, you know, the mechanism for getting defects corrected. We will iron out some of the misconceptions that people have about defects. You know, how long are you liable for defects for? You know, to give a bit of a spoiler, it's not 1 year after completion or 2 years, whatever you've written into the contract. It will probably extend much longer than that. It'll be something more like 6 years or perhaps even 12. And I'll talk about that with reference to a couple of UK statutes as well. And then finally, our final topic, which I will very briefly touch on because, you know, we're in 2023 at this point. The NEC4 has been around since 2017. So there's no real excuse to be using the NEC3 at this point. But for those of you that are, you know, trained in that form of contract, and those of you that have experience in it, I'll touch on some of the key differences. And I'm also going to provide everyone, as a bit of a bonus, a memo that I provided to all of our clients about a year and a half ago, which sets out those differences in a bit more detail. And I'm going to provide that as part of the materials for this course because I'm a nice guy. So hopefully everybody's excited. Let's get stuck into assessing compensation events with reference to our little work example. So this example is one that I worked on in real life. I've changed, you know, pretty much all of the facts. You know, the core concepts are the same, but to protect privacy and confidentiality, I have changed all of the facts and figures just so that no one can glean from it what actually happened in the actual case I was working on. So to give you an idea of what this was about, rock excavation was required as part of this wastewater treatment works. This was a case study I used on a previous training course. So obviously wastewater treatment works, you need to excavate quite a lot of rock out of the ground or something out of the ground so that you can sink the tanks. You get the picture. It's very dependent on, you know, the ground conditions being as described. The other fact that's important here, which we'll touch on why shortly, is the fact that it is an NEC4 engineering and construction contract. Again, the black book, this one, the one that we've been training ourselves on as part of this course, and it's an option A version of that contract, which is the lump sum form of the NEC. Generally speaking, this doesn't actually matter in the slightest, and I'll maybe touch on that point as a preliminary point. Regardless of what option you're dealing with, when it comes to compensation events and their assessment, the mechanism is the same under all of the main options. What you don't do, and what quite a lot of people fall into in terms of a trap, is that they go to option A and they know that it's got this activity schedule. Or if you go to option B, its document is the bill of quantities. And that's the document where you've got all of these rates and all of these prices provided by the contractor at tender stage. So that's what those documents look like. What people tend to think you do is use these documents to assess compensation events. No, you do not do that. Under option A and option B, you forget about those documents and you go back to first principles, which is why the assessment of a compensation event is the same under all of the options, bar one very subtle difference, which is irrelevant for the point that I'm making here. For option A and option B, it's exactly the same. So in terms of our little scenario, mindful of the points that we've just touched on, contractor has started on the site, put the digger bucket in the ground and realizes that they're unable to excavate limestone using the standard methodology set out in their quality submission or in their method statement. So they're going to go onto the site. The limestone was described as being nice and soft, and they were going to rip it out with the back of a digger bucket, effectively. That's the methodology that they had planned. They carried out some core tests on the site to establish the actual strength of the rock. Again, the data here is important because it objectifies the hardness of the limestone. And they discovered that instead of it being 20 megapascals, which they would have expected to be there based on the site information. It was actually 150 megapascals. So for the geotechnical engineers in the room, you'll know an awful lot better than me. 150 megapascals, very, very hard. 20 megapascals, quite soft, friable, easy to be broken out. Obviously, it depends on a range of other factors, you know, the fract ratio and all of these other things, which again is well beyond my memory at this point, and the way that the beds are tilting and all of this. But for the sake of argument, very, very soft is what should have been expected, and very, very hard is what was actually encountered. So first question that I'm going to throw out there to the audience: what's the first thing you do in this scenario if you're a contractor? Before we start looking at assessing it, what alarm bells should be going off and what should you do under the contract? We covered this last week. What do you think? Early warning notice. What do you think? Should you early warn this sort of problem? This was one of the points we did cover last day. CEN, Jerry, exactly. Why would you not early warn this? You know, what's the point of an early warning? It's to avoid problems, isn't it? What has happened here? It's actually happened, Richard. Exactly. You've put the digger bucket in the ground. You've got the core test. They've come back from the university or the lab, wherever it happens to be, and they have said the ground is far too hard compared to what was expected. So NAS, you don't early warn in this scenario. That ship has sailed. You jump straight in and you notify it as a compensation event under 60.13. Everyone crystal clear with that point? That's what we talked about last day. If you gave an early warning here as a contractor and you didn't notify it as a compensation event within that 8-week window, the early warning is not enough to stop the timer. So you have to be very careful here. Does anyone know what compensation event you would be notifying it under here? Again, there's a list of compensation events at 60.1. There's 21 of them within that clause. Does anyone know which one it would be? 60.1 bracket. Anyone got the contract in front of them? Number 3, nope, it's to do with the accepted program. Seamus Gillen, nope, it's an active prevention. Good to see you, Seamus, as well, by the way. Number 19, Seamus, only applies if none of the other compensation events are applicable. And in this case, one of them would be if you haven't changed the contract. I'll not wait any longer. It's 60.112. It's the ground conditions event under the NEC, which basically sets out if you discover physical conditions which are worse than the physical conditions a reasonable contractor would have expected based on the site information, etc., then you can claim, and this compensation event will be triggered. So that's the preliminary points. Let's now start to look at how we assess it. So we have assumed, and again, just to set the assumptions first of all for this worked example, the contractor has properly notified it. NAS, they didn't need to early warn. They've jumped straight in and they've notified it as a CE. The PM has responded under clause 60.14. This is the clause that we covered last day that requires the contractor to say yes or no within 1 week. And again, that's all the PM has to do at this early stage. They don't have to start talking about money. Like I said last day, I would advise people to not talk about money at an early stage. I would advise them simply to ask for that yes or no answer. Dear sir, here is our borehole survey. It's proving that the ground is 120 megapascals. Here is the borehole survey from 1995 that was appended to the site information, and it sets out that it should only have been 20 megapascals. There's clearly a difference here. We priced it based on 20. It's actually 120. Therefore, this compensation event has been triggered. Do you agree or do you not? And we're going to assume here that the PM has a bit of sense and they have agreed that this is a compensation event. What the PM does at that point, when they accept the compensation event and they give the green light, is that they notify the contractor and ask them to provide a quotation. And this is very much where we left it last day. We looked at the timeframes for that. Contractor, as we saw last day, has got 3 weeks to provide that. And what we're now looking at is how does the contractor put that quotation together in terms of the time and in terms of the money. Paul's got a good question. If they say no, can you go back again with more evidence? Absolutely, Paul. One of the other compensation events, 60.1, oh, you put me at a loss here. I think it's number 9, and I'm just going to double check that just to be absolutely sure. 60.1 was close, it's number 8. The project manager or the supervisor changes a decision. So they originally decided that the compensation event was not a valid compensation event, but Paul, if you can provide them with more information, they can change their mind, and if they do change their mind, that will be a fresh compensation event under number 8. So hopefully you're happy with that, Paul. Kieran has got another point. During the 3 weeks for a quote, do the work stop? No, they do not. When it comes to dealing with ground conditions and any other compensation event, the contractor has to react competently and promptly, Kieran, which means you carry on with the work. So you have to take reasonable steps to mitigate your loss. And that's a common law rule. The NEC calls it reacting competently and promptly, and that's the obligation. So you carry on with the work, Kieran. You bring in the heavier gear and you argue about it tangentially with that or in parallel with that. So Paul, Kieran, good questions, keep them coming. So this is where we left off last day. We have to go away and provide this quotation, and what you then have to do as part of the quotation is look at the impact of this event in terms of the money, depending on what currency you're working in, and also the impact on the program in terms of what delay is associated with this event. What we're about to do now is march through both of those pieces. The first piece of advice I would give a contractor in approaching this is to look at the program first. In my opinion and in my empirical experience, if you can get the program right and you can forecast the effect of the event accurately looking at the program, then it makes putting together the money side of the quote an awful lot easier, which is why I would always advise you to have a look at 63.5 first of all, because it's the clause that sets out how you work out the impacted program or the impact on the program. So this is what clause 63.5 says. Again, it's not the easiest clause to read. It talks about the delay, in other words, the extension of time that you can get. The NEC doesn't use the words extension of time, that's JCT language, but it means the same thing. So the EOT that you are entitled to is assessed as the length of time that due to the compensation event, the planned completion date is later than the planned completion date shown on the accepted program. Now, to me, that sounds very circular. You know, planned completion is later than planned completion. It doesn't roll off the tongue that nicely. So what I'm going to do is explain that concept with reference to a lovely little animated diagram, which we've got just here. So what this clause aims to do is work out the delay to the completion date. And the completion date is your contractual deadline. It will be within the contract data. This is the date that you need to complete by. If you have option X7 in your contract and you fail to complete on time, under option X7, you'll pay delay damages. So it's a very important date to meet. So how do we move that date is the question. So to work through this, we've got a little hypothetical construction sequence, nice and easy. Mobilization, we've got our rock excavation, the superstructure, and a bit of commissioning of this wastewater treatment work. So it could be any project with a bit of design work that is off the critical path. As you can see here, this design work can, start later. This is the earliest start, but it can move. But ultimately, it needs to be finished before this commissioning activity starts. So it's an off the critical path activity, dead easy. What you do by plotting your methodology like that, and this is what every program should look like, albeit this is a very simple version, is it should arrive at what we call the contractor's planned completion date. Now, I briefly mentioned what that was a couple of weeks ago, and when we looked at the program and some of the differences between the NEC and other forms of contract. But what that effectively does is create what we call terminal float. So by showing the date that you plan to achieve completion, just so you know, the word completion is important, capital C. It's a defined term within the NEC. That's equivalent to practical completion under the likes of the JCT, or if you're used to working in the Republic of Ireland, substantial completion under the Public Works. It's the same thing. It's the date that the contractor plans to finish the job. So as you can see here, by simply plotting the critical path through the project, they plan to finish 2 weeks before the actual completion date. Because of the way that this word or this clause is worded, this creates what we call terminal float, and it's the difference between and the contractual deadline. And the point of this wording is you have to work out the impact of the planned completion date of the compensation event on the planned completion date and prove how much later you plan to complete as a result of the compensation event. In other words, you don't have to be pushed beyond the completion date to be able to claim an extension of time under the NEC. The only thing you have to prove is that you're planning to finish later than you originally planned to. So hopefully that makes sense. It's a protection of the terminal float mechanism. So what does that look like then in reality? So let's say we have a compensation event at the start of the project. Just before we get there, there's two other types of float that I just want to explain. They're less relevant here, but it's more just an FYI. Terminal float is category 1. Free float is the float that we have in this design work activity. So point being, it can start realistically in here somewhere because it's not going to impact the critical path until that point. So it can move freely, and we call that free float. The third and final type of float on any construction program is what we call time risk allowance. And that's the difference between how long you think an activity will take. Let's say you think the superstructure will take 2 weeks, but you add an extra week onto the end of it, showing a total duration of 3 weeks. That extra week at the end is time risk allowance. And that's just contractors' float for dealing with issues that arise during the superstructure. A delivery might not be there on time. The weather, which again, to a point, is the contractor's risk under the NEC. It might be too windy to get the craneage up, whatever it happens to be. So you would allow a little bit of extra time there, and that's another type of float. What would happen here in this scenario if that activity was completed within 2 weeks, hypothetically, and you didn't need this 1 week of time risk allowance? Does anybody know what would happen there? Interestingly, where would that float go, is my question. Kieran, you do keep it, and why do you keep it? What would happen to the rest of this program? You want to jump on the microphone, Kieran, and explain it? Anyone? So what would happen here is the commissioning activity would move to the left-hand side of the program. Assuming the commissioning took the same time, the planned completion date would move towards the end or to the left-hand side. So what that would mean is the 1 week of time risk allowance will be placed into the terminal float. So you're right, Kieran, you would keep it. There was a question there on an option A. How does time risk allowance work under option A? Is the contractor obliged to show in their program the TRA for each activity? Yes. Under clause 31.2, you are required to show time risk allowance. And also when it comes to an option A contract, you have to demonstrate how the activities on the activity schedule relate to the items in the program. And when you read all of that together, you do need to show the time risk allowance for all of those activities, Mr. JV, whoever that is. So the answer to that question is a resounding yes. So back to where I was going with all of this. If you have a compensation event then at the start of this rock excavation activity, which is what we're looking at here in earnest, as you can see, this rock excavation activity is going to be prolonged. It's going to be prolonged by this period of X. You can show that in a number of different ways. You could add it in as its own bar. You can add it to the start of the activity, add it to the end of the activity, stretch the activity out. It doesn't really matter. Then there's no rules that require you to show it in a specific way, as long as it's clear. And I think the clearest way to do it is something like this. So you can see here that as a result of this compensation event having to dig out this extra hard rock, the rock excavation activity has expanded by this period of X. And what you can see happening here then is this: the whole critical path is shifting out by the same duration. And by virtue of doing that, the planned completion date is shifting out by that period of X. So hopefully everyone can see that. And that's what this part of clause 63.5 is describing, that what is the impact of this compensation event on your planned completion date? You know, you have to demonstrate that planned completion is later than planned completion shown on the accepted program. So to, you know, illustrate that, this is date number 1, this is the original planned completion date, and this is date number 2, which is the revised version. And that's exactly what that clause is describing, just illustrated on this little diagram. Out of academic interest, let's say there was a compensation event after this event had happened that prolonged the design activity. Would there be any impact on your planned completion date in that scenario? Let's say you were asked to do additional design work, which is a compensation event under 60.11. No, Paul, as you can see, there wouldn't be any critical delay with that because of the free float. Unlike terminal float, free float is owned by the project. So whoever gets there first can utilize it, unlike the terminal float, which is always owned by the contractor. So having established all of that, what we then have to do is shift our mind over to looking at the money. But what you have done in this fairly rudimentary exercise is prove the delay element under 63.5. And this is what you should be doing to your programs when providing a program along with your compensation event quotations, impacting it to show the delay to your planned completion date. And by virtue of your planned completion moving by this X period, you get an extension commensurate to that, to the completion date. In this case, it would be that period of X. So having done that, having established the impact on the program, the next thing you have to do is look at the money element. So you jump back in the contract and you look at clause 63.1, which describes how you work out the impact in terms of money due to this compensation event. So like the clause before, in my opinion, not the easiest thing to interpret the way it's written out, and it is different to how most other contracts operate as well, to put it lightly. It's very different. So in terms of working out the change to the prices, in other words, how much extra money do you get? You know, what's the delta over the contract sum? Contract sum. That's what we're describing here. How much extra money do you get? There's 3 parts to it. Part 1, part 2, and part 3. Part number 1 is all about looking at the actual cost up to a line in the sand. And that line in the sand we call the dividing date. And I'm going to explain what that is in a bit more detail shortly. The second element is looking into the future. You don't have the ability to work out the actual costs because the second bullet point requires you to look prospectively into the future and forecast how much the extra work is going to cost you. Hasn't happened yet, so you have to forecast it. Again, after that dividing date, it becomes a forecast, and I'll explain the dividing date shortly. The third part is much easier, and I'll come back to it later on in tonight's lecture. It's what we call the resulting fee. The main work is in establishing these 2 parts. Once you've established those parts, it will spit out a figure, let's say 100K. You then have to work out the fee. You simply do that by multiplying the 100K times a fee percentage, which would be something like 10%. So in this case, the resulting fee would be 10K. That part's just a mathematical addition at the end, so don't worry about that one too much, but we will look at it later when we start looking at figures. So in terms of this dividing date then, and what exactly that is, it is a line in the sand, okay? It's the line in the sand that separates, for the purposes of assessing a compensation event, when you look at actual cost records and when you don't, when you start looking at forecasted records and looking at it from a theoretical point of view. Again, looking at actual records up to the dividing dates, you know, up to this point, that's what bullet point number 1 is describing. Then you forget about as-built records and you can forecast the effect moving forward. And that's part 2 of that definition. Question there, Paul Fortune, what about non-critical delay that has other impacts? Is it all captured in the cost? Yes, Paul, obviously every scenario is different. You know, if you have to, you know, take resources off another activity and put it onto a non-critical activity, then the non-critical activity could even become critical because the resources are off the critical path. There's lots of things you would take into account there, Paul. But if it's a straightforward case of having the same designers just doing the work for a little bit longer, it would simply be a case of looking at the cost. But you're dead right. You have to look at it in the wider sense of, you know, what resources have to be moved about if it's a non-critical activity. Happy with that, Paul? Make sense? I think you're hinting at the right answer there. Yeah. So as I was saying, you do need to wrap your head around this dividing date point, because it's the line in the sand that, again, beyond it, looking into the past, you look at actual records, and everything after that is based on a theoretical account of the forecasted records. In terms of what the dividing date is, it is drawn in the sand at the date the notification is given, okay? So in the scenario that we're looking at here, the contractor has notified this compensation event under 61.3 right at the start of this rock excavation activity. And that makes life an awful lot easier for this calculation, because it means we're looking at everything on this forecasted basis. If the contractor had notified it halfway through, and someone earlier on, I think it might have been Kieran, mentioned, you know, do you keep doing the work in the interim? And the answer to that is yes. So if you notified it halfway through and you'd already done half of the work, and because you've notified it at this later date, you would look at the actual cost for everything up to that point, and then you would look at the forecasted cost moving forward. Again, that line in the sand changes simply what records you look at. We've got a question here from JV. Again, quite a long question, JV, and I think it's slightly off the topic that we're looking at here. I'll come back to you on that at the end. If you want to drop me a private message, we can look at that. So having established the dividing date, and we know that it's the date here of the contractor's notification, then the question that you have to answer effectively is, what is the forecasted effect of this event, this hard limestone in this scenario, on the defined cost of this rock excavation activity? And we're going to look and break that down in a bit more detail. In other words, what extra cost have I suffered as a result of this hard limestone? You don't have to wait until you've suffered those costs. You have to look at it into the future and guess effectively. The word guess, you know, has connotations that you're putting your finger in the air. It's guesswork in the same way that you guess a tender sum. You know, you're tendering for it. You haven't done the work at this point, but you're taking into account all of these things that might happen, and you're giving it your best estimate effectively, and you're forecasting the cost of the compensation event. This is totally different conceptually to how most other contracts work, where it's totally alien to guess into the future. What you would do under most other forms of contract is wait and see. You would wait for all of the effects of the event to be felt, and then you would look into the past, get the contractor to prove all of their actual costs, and you would pay them accordingly. But the NEC doesn't do that. It's all built around making this contemporaneous and forecasted assessment. So what I'm about to do now is break down some of the other words that we have within this definition, particularly that word defined cost, or those words define cost, because it's not obvious what it is. So what it boils down to is being able to claim certain costs and not being able to claim others, okay? Under the NEC, when it comes to a compensation event, you can only claim costs as a contractor, claiming the money, if those costs appear on this document, the short schedule of cost components. If you're under an option A, that will be the short schedule, option A or B. If you're under any of the other options, C through F, it will be the long schedule. There's almost no difference between the two. The long is slightly more detailed, but conceptually it's the same thing. It's a list of costs that are recoverable, but we'll park that point for now. And we'll come back to it shortly, and I'll look in a bit more detail at what exactly the schedule of cost components is. But if you do happen to have a copy of the contract in front of you, you will find a copy of the schedule of cost components starting at page 71. So it is literally a page of things that the contractor can claim. And the long schedule is 3 and a bit pages long. The short schedule is 3 pages long. It's dead short, and it lists out an exhaustive list, and I must stress it is exhaustive, of everything the contractor can claim. So the next thing you have to look at, bearing in mind that this schedule of cost components sets out what you can claim, is how to quantify everything in that list. So this is a two-step process. Step one is to look at the schedule of cost components. I have suffered this cost. Is it on the schedule of cost components, yes or no? That's the first thing that you have to establish. Apologies, my screen's going to turn off there. The second thing that you have to do, which is prescribed under clause 50.2, is work out what rate you apply to it. So what is the rate? To give an example, let's say you have a site agent that you're trying to recover costs for. Because of this limestone activity, your site agent is on the site 10 weeks longer than you had allowed for. That's part and parcel of this claim. So the question that you have to ask yourself, first of all, is the site agent on the list? If you go to the schedule of cost components, and I will go to it just now and I will read it out, you will find a bullet point that covers a site agent. If you go to heading number 1, it sets out that the contractor can claim people who are directly employed by the contractor, such as a site agent, and whose normal place of work is within the working areas, such as a site agent who works on the site. So yes, it's on the list. You can recover them. Happy days. That's step 1. Step 2 is to work out what rate you apply to that site agent. And under the NEC4, the first place that you go to look is in the contract data. And you can see that here at clause 50.2. That defined cost includes amounts calculated using rates and percentages stated in the contract data. So for the likes of a site agent, you will go to contract data part 2, and the contractor at tender stage might have given you a rate for that, say, whatever it happens to be, 60, 80 pounds an hour, depending what part of the country you're in, I suppose. And there you go. That's how you work out the costs associated with the site agent. Let's say for whatever reason you don't have that. If the contractor hasn't put any people rates in the contract data, then you read on the remainder of this paragraph. And other amounts at open market or competitively tendered prices. So you would then have to go and work out what is the open market cost of a site agent. And that's how you complete the exercise. They're on the list. They're on the list of cost components, and you now apply the appropriate rate. It's either the rate in the contract data, and if you don't have that, it's open market or competitively tendered. Question here from Jason for a short contract, engineering construction short contract, the published list of equipment used for CEs. Is there an applicable list for work in Northern Ireland? SECA is only to GB, or can you agree to use open market rates? So what Jason is describing is working out the cost of equipment. So as we'll see on this next slide, the first thing you have to look at is all of the different components that you can claim within the schedule of cost components. The example that I've used up to this point is people, and I am going to answer your question, Jason. I'm just going to use this slide to do it. So, conceptually, question 1 that you have to answer is, does the cost that I'm trying to claim fall into one of these buckets? Does it fall into the definition of component 1? Does it fall into the definition of component 2, etc.? So the example I used was a site agent, and I read out the part that is relevant, and we all agreed that they form part of the people costs. Jason would have to ask himself the exact same question. Let's say he is trying to claim the cost of a whacker plate or a roller, whatever it happens to be, Jason. You would go and you would look up the definition of equipment within the schedule of cost components, and a whacker plate and a roller would fall within that component. So the answer to that question is yes. And as we saw on the previous slide, that allows you to claim it as part of your defined cost. The other part of Jason's question then, if you don't have a specific rate for a specific piece of equipment within the contract, what you're allowed to do is use a published list. Published list. And the way that that component is worded, again, if you go to page 71 and onwards and read it, you look in the contract data to see if there is a contractor rate for the item. If you don't have that rate, then you go to the published list if you have one. If you don't have a published list, then you go to fair and open market rates. So again, it's a trickle-down approach, and that's all set out within the confines of the contract. In terms of a published list, and I'm finally getting to your question, Jason, an example of a very common list to use is SECA, which is a publication by the Civil Engineers or Civil Engineering Contractors Association. They've pulled together data from all over the UK, and they set out a list of rates. And the point that Jason is making is exactly right. Those rates are based on a GB average. So depending on where you're working in the country, they're either going to be very, very good. So for example, in Northern Ireland, where plant and equipment is traditionally slightly cheaper. But if you're working in London, then the rates will not be very good. And depending on where you're in the country, it'll be somewhere in between. So what the contract allows you to do in that scenario is apply a percentage multiplier to that published list to account for that fact, Jason. So the fact that you're working in Northern Ireland, it would be fairly typical to see someone putting in, say, minus 10% against SECA, which effectively lowers that average price to make it more like the open market rates in Northern Ireland. Likewise, if you're doing works in the Shetlands or somewhere way outside of the normal working arrangements, you might want to put an addition onto that. You would say SECA plus 10%, whatever the case happens to be. And the direct answer to your question, Jason, no, you don't use open market rates. If you have the published list in your contract, you use it, even if that list results in you getting a very favorable rate. But if you're a wise contracting authority, you would want to make sure that you're checking that as part of the tender competition to avoid that very problem. Good question, and it dovetailed very neatly in just to the slide that we're looking at here. So the point with all this is, all of the contractor's costs, they have to fall somewhere onto this list. If they don't fall onto the list, then you can't recover it. And it's deemed to be captured by this generic fee percentage. What's the headline item that you don't see on that list? You know, what are we all in business to make at the end of the day? You know, there's a profit, Graham, profit, Ashley. Yeah, we're all chiming in on that one. We all know the right answer there. Profit is not on the list. Okay, so what does that mean? Where can you recover your profit as a contractor? Where's the only place that it can be recovered? And therefore, where must you account for it when looking at this percentage, the fee percentage? Okay. What else do you not see on that list? Overheads is where I was going with that, Graham. There are no overheads on here. Overheads cannot be recovered as your defined cost because it's not on the list. Go to page 71, you'll not see overheads. So your printers, your receptionists, your heating costs in head office, all your tendering, your estimating team, health and safety, all of that stuff that's not on this list has to be captured within the fee percentage. That's why it's not called profit percentage, because it's not that. It's much, much broader. Prelims is slightly different. Prelims, if they are direct prelims, so you know you have a management resource on the site, you have toilets, canteen, welfare facilities, Graham, if you're calling that prelims, then you know they would be captured here. The people, the management staff, charges, which would be your electricity on the site, your site huts could potentially form part of equipment. So those elements could be recovered. But if you're talking about prelims in the sense of unabsorbed prelims, you know, site office people or head office people, then no, they would be captured by the fee percentage, Graham. So you do need to break it down in that way. So this was the first question that I posed on the previous slide. Is it on the list or is it not? And that's always the first thing you have to do. The second question that I posed on the previous slide is putting the actual rates against this. And it's a trickle-down approach. You use the rates in the contract data. And this links back to your question. Who was it? Jason. You know, if you are using SECA, then you will have rates in the contract data because you have set out that you will be using the published list, which is SECA. So you would use those. But only in the event that you don't have a rate, then you use open market or competitively tendered rates. What a contractor or what a PM is not allowed to do is cherry pick. If you have a rate in your contract data, The contract requires you to use it. If they don't like the rate, that's tough titty. They have to use it. What I have seen in the past, which I think is quite a cheeky contract amendment, clause 63.2, I think it is under NEC4. It used to be a different clause number under NEC3, but it allows the PM to agree with the contractor to use, lump sums to assess compensation events. And what I saw a number of public sector bodies and other organizations doing is going in and tweaking that clause to allow the PM to cherry pick. So if they didn't like the rate, they could go open market if they wanted to. I think that's very unfair. I think it circumnavigates the point of this mechanism, which is to give you a very clear way of assessing change. So don't do that would be my advice, or do that if I'm advising you as a client organization. So what this little flow chart boils down to is clause 50.2, which is the clause we looked at on the previous slide. And again, just trying to map it on to give you a bit of a flow chart to work through, but this is the exact thing that clause 50.2 prescribes. I've got a question there. How would you capture inflation or upward costs? The only way to do that under the NEC is option X1. So if you don't have secondary option X1, which we dealt with back in week 1, then the risk of inflation lies with the contractor. So if they've got rates in their contract, they are stuck with them. But if you're using X1, you still use the original rates, but by virtue of having X1, the whole cost of the compensation event is uplifted based on how the index has changed. If you're using BCIS and you've linked it to whatever index, which is 1.00 at the start of your contract, and it moves by the end of the second year to 1.25, then the cost of those rates goes up by 25% effectively. So transfers the risk to the employer. Question there from Graham, final one before we move on. Regarding the quotation process, what if the contractor gets a quote or set of quotes from their regular suppliers that they know and trust, and the ER, project manager, NEC language, provides an alternative quote from a supplier that you do not have an account with or any reliability for their ability to supply? So the NEC is premised upon the contractor making the initial assessment of the compensation event, Graham, but the PM ultimately is able to make its own assessment if it doesn't agree with that. So the PM could, in theory, make their own assessment. What the PM can't do under the NEC is dictate who the contractor goes to. The contractor is free to subcontract if they want. The PM or ER, it's PM under NEC, can't do that, Graham. So the PM will be in a funny position there where they're trying to assess it using rates that aren't actually applicable to what the contractor is using. And that sounds like a rife ground for disputes to crystallize, Graham. So we think the PM will need to be very careful of what it's doing there, because that's out with how the NEC contract is designed to work. So this slide is just an extract from that document that we've been talking about, that short schedule of cost components. It's a really, really important document, and I can't underemphasize that enough. As you can see here, it's only 3 pages long. Get a copy of it, highlight it, annotate it, write in examples beside each of the bullet points like I've got in my contract. Because to be able to claim a cost as a contractor, it has to fall somewhere onto this list, as we talked about on the previous slide. So this is an example of what it looks like. So this is what the contractor can claim in terms of its people, in other words, its labor. It can claim anything that falls into one of these 3 headings. There's the one that I read out earlier, people who are directly employed by the contractor, so employees, and who normally work within the working areas. So for example, who might that be? Let's get an example of each of these before we move on. Who would fall into that first category? Contractors, employees who work on the site. Site agent, Gordon, exactly, don't overcomplicate it. Next bullet point, people who are directly employed by the contractor, so employees, who normally work not within the working areas, so they're not site-based, but who come to the working areas proportionate to the time they spend working in the working areas. In other words, an employee that goes to the site occasionally. What do we think? Director, health and safety, QS, planner, bingo. You get the picture there. People that are not always on the site full time. Third bullet point, people who are not directly employed, but who are paid for by the contractor according to the time they work within the working areas, such as the site. Designer, Paul, labor only, subcontractors perhaps. You get the picture there. Contractors as opposed to direct employees. So you get the picture there. Contractors and PMs alike, you need to have an intimate understanding of everything that's on this list. See what I've done there? Just by putting a little example beside each one, that's what I recommend you do. If you do that in your contract and you get this thing marked up, it'll make interpreting it an awful lot easier. So let's go back then to our worked example to start to apply some of this theory. So what you have to do is a two-part exercise. You know, at the end of the day, we're working out the extra over that the contractor has had to pay out as a result of this hard limestone. So the first thing that you have to do in working out an extra over is work out what the baseline was. So work out how much the contractor was originally going to pay out. And you do that by looking at their planned methodology, by looking at the accepted program. Remember, we talked about this before, clause 31.2. You have to set out all of the principal equipment and resources. So all of this information should be readily available if the PM is doing their job right. So you're able to establish that they were going to use 35-ton machine with a shank gripper, as pictured here, to dig out the limestone and effectively rip it out. Load that into a dumper using a 20-ton machine. The dumper then removes all of the spoil to another location within the site, and all of that was going to take 10 weeks, which again, that duration comes from the original program. All of that information should be readily available. The other side of the equation is to work out how much it's going to cost them after this hard limestone was discovered. And the point is, this is all done on a forecast basis. So you don't wait until this has all happened. You sit down at the time, you get your program out, and you look forward into the future. It's almost as if you're tendering for a new job. That's the mindset that you have to have. So based on how hard we think the rock is and all of our walks of the site and all of our further investigation, we forecast, guess, again, that's the word I used earlier, it's not correct, you forecast that it's now going to take 3 35-ton machines, all with rock hammers, again, as pictured here, to peck away at the rock. You still need the same 20-ton dumper. At the end of the day, it's the same volume of rock that has to come out, it's just much harder. So in theory, you don't need a bigger excavator to load it. If anything, it could be a smaller excavator because it's going to be done slower and not be in smaller pieces. You still need the same dumper, again, same volume of rock, but because it's going to take longer to peck out all of this hard rock, you're now forecasting that it's going to take 14 weeks. It's going to take 4 weeks longer than anticipated. Does all of that seem reasonable, you know, to do on a forecast basis? Do you understand what I mean now by forecasting? You know, you have to look at this into the future to see what exactly needs done to resolve this problem. What then about risk allowances? You know, if you're tendering for a job such as this, you know, you don't know what the rock is like throughout the entirety of the site. It's a borehole survey. You only know what the rock is like at that very specific point. It could be harder in between the boreholes. What would you do as a contractor in that scenario? Time risk allowance? Absolutely, Kahinde. So, you know, in this, you have allowed, let's say you think it was going to take the original 10 weeks, but you allow an extra 4 just to be safe. That extra 4 weeks is your time risk allowance. What else? Not only time risk allowance in your program, but you would also allow what? Cost risk. Absolutely, Paul. So you might build in a contingency pot within that, and you're absolutely entitled to do that. Under clause 63.8, the contractor is entitled to build risk into their quotation. PMs might not necessarily like that, but that's what the contract says. Because you're forecasting the effect of this compensation event, you build in the TRA, as Ashley and Kahinde say, and you also build in the cost risk, as you say, Paul. And all of that is perfectly legitimate under clause 63.8. Another good point, Richard. What do you think happens if you underestimate your forecast? I'm going to throw that back at you. Whose risk is that forecast, do you think? It's the same as tendering for a job for the most part. Tough luck, Nicola. Absolutely. It's the contractor's risk. And that is why, from the contractor's perspective, this clause is so important. Because if the risk materializes and you haven't allowed for it, that's your problem. Okay. And what about the other side of that coin? What do you think the PM can do if they think the contractor is adding too much risk into the pot? What do you think the PM could do there? And this is a mechanism, in my opinion and experience, most contractors or most PMs aren't aware of. PMA, reject it, sue him, Kehinde, not quite. Challenge the contractor, nope. Again, it's a mechanism most PMs aren't aware of. What they can do is state assumptions. They're called PM assumptions. So, for example, the contractor in this scenario has allowed an extra 4 weeks of time risk allowance. The PM could say, "Dear Mr. Contractor, assume for the purposes of your quote that you can do it in the original 10 weeks and base your quote on that accordingly." That's a perfectly legitimate thing to do. And what then happens if it ends up taking more than 10 weeks? What happens in that scenario? Again, this is a mechanism that's often misunderstood. A new compensation event, Gordon, yep. And there is actually a very specific compensation event for that, 60.117, which says if a PM's assumption turns out to be wrong, it's a new compensation event. So from the PM's perspective, if they don't like risk, they can get rid of the risk by taking the risk on themselves. The contractor no longer has to price it at that point. They can plow on and do it within the original 10 weeks. And if it takes 10 weeks, happy days. They're not paying for the privilege. But if it takes longer than the 10 weeks, it'll be a fresh compensation event by virtue of that 60.117. I have that on the next slide. So just to introduce you to that topic. So this is the first part of the exercise, is to look at this holistically and to understand from broad brush purposes, what is the difference in the equipment and the labor, etc. You then have to transpose that onto Excel effectively, which is what this next step is. And the way that I would always recommend doing that is to set up your Excel spreadsheet so that it breaks down the cost into the various different components within the schedule of cost components, which we talked about before. All of those 8 headings should have, people do it 8 different tabs, or you can have, a number of different rows within your spreadsheet for people, a number of rows for equipment, but you should be breaking it down in that way, in my opinion. And this is what it looks like. So you then apply the rates in the contract, the open market rates, if you don't have any rates in the contract, to work out the cost before this compensation event happened. So this is using all of that equipment on the previous slide, the one 35-ton machine, the one 20-ton excavator, the dumper to shift it off the site, and prelims for 10 weeks. That's, however, only part 1 of the exercise. Again, you have to work out the cost before, but you also have to work out the cost after. And again, that's using all of the other equipment on the other side of that slide, the 3 35-ton machines, the extra time that it's going to take if you haven't transferred that across to the PM, etc. I'll come back to your question, Kieran, just once we get to the end of this slide. So that's how you work out the cost of a compensation event in terms of the extra over. You've worked out the before, you've worked out the after, and the next step is simply a case of taking one away from the other. So again, in that case, it'll be 250K, and we'll come back onto that shortly. There's that clause creeping in that I was mentioning earlier, that for the purposes of this quotation, Mr. Contractor, assume that you can do it in 10 weeks. What did we call that earlier? There's a name for this mechanism. It's called a PM what? Assumption. Exactly. So because the contractor was pricing their quotation based on this extra 4-week duration, again, that time risk allowance, as you say, Kehinde, you can get rid of that as a PM under 60.16 by stating it as an assumption, which effectively transfers the risk of that assumption back to the PM and the employer stroke client. And ultimately, if that assumption turns out to be wrong, that's a new compensation event, and it would entitle the contractor to claim a further compensation event for it. So hopefully that's clear. That's what we discussed on the previous slide. But assuming that doesn't happen here, let's see what the final step in this process is. So what we've done by looking at the program, looking at the forecasted effect on the resources, looking at the resources before based on the program and the method statements, we have been able to work out the answer to that question that we posed way back when we started looking at the program of this particular event. And that is what the forecasted effect of this compensation event is. And as you can see here, you take one away from the other, and that gives you your 250K. What's the final thing that you have to do before you move on? That's bullet point 1 and bullet point 2 of clause 63.1. What was that third and final one? No, Ashley, the delay is dealt with here. You've accounted for the delay in your people costs for being on site 4 weeks longer. Again, that's why the people costs have gone up so much. You've got 2 extra drivers for the 2 extra machines, and they're also on site for 4 extra weeks. No worries, Ashley, it's probably my fault for not explaining it. Gordon, Craig, yes, you have to add on the fee. How do you work out the fee? Under NEC4, it's dead straightforward. You simply multiply the 250K figure, which is your change in defined cost, by the fee percentage in the contract data part 2. And you can see here that will result, if it's 10%, it's dead easy, in a fee of 25K. So the total value of this compensation event is 275. And that's what we've done, folks. We've marched the whole way through this event to work out the forecasted effect. Again, not a pick of work has been done at this point. All of this is on paper. We're looking into the future. We're forecasting it. Contractors in the audience, because you're forecasting it, you're taking the risk. So make sure you're building risk into that pot. You know, make an allowance within your people costs for someone being on site an extra week if you have to. Make allowance within your equipment, and you see the point. Good. Is there any questions on that? I think there was one question that I didn't get to. Apologies, Kieran. Does a new quote have to be done for a new compensation event, or just roll over the first compensation event quote? Strictly speaking, you should have a quotation for each compensation event. That said, the NEC guidance notes does, appreciate that if you've got lots of compensation that's happening at the one time, then coming to an agreement between yourselves to wrap them all up is probably the most sensitive thing to do. But strictly speaking, and if you're just applying the black letter of the contract, each compensation event, separate quote, but commercial reality would subsume that. Question, Kieran, in relation to the PM, your question was in relation to the assumption being wrong. No, it would be a brand new quotation for the additional time frame. So if the assumption was to assume that it took 10 weeks, slide going haywire there, and that assumption turned out to be wrong, you couldn't do it in 10 weeks and you had to do it in 14 weeks, then the new compensation event would be for the extra over in that 4-week time frame, Kieran. So yeah, it would be a separate compensation event. JV, I will absolutely share my email address on the chat, and I'll also have it on the last slide as well, so you'll certainly get that. So this is then the conclusion of our little worked example looking at the money element. We started off all of this by looking at the program. And again, I recommend you do that, because when you impact this program, you can see how much longer this activity is going to take. So again, in our little hypothetical example, the contractor initially thought it was going to take 14 weeks. So this period of X was going to be 4. But we then looked at the assumption mechanism, and this whole period of delay was, they were able to mitigate that by assuming that it was going to take the original duration of 10 weeks. But for the reasons that we covered on the previous slide, if that assumption turns out to be wrong, then you can open it up again and get the delay that way. The other important reason that I said way back at the start that you should start with the program is you can then look at what the resources are. Looking at the original program, we knew here it was a 35-ton machine, 20-ton loader, dumper, and it's going to take 10 weeks. All of that information is gleaned from the program. You then impact the program and you can see what the impact on those resources are. And it just makes that whole calculation an awful lot easier if you can draft it up in that way. Question there, too many compensation events could drive up the overall cost. to the project to the point of failure? Yeah, potentially it could. The other way to look at that is that's the client's problem. Compensation events are client risks. The way the client should have got around that is by giving the contractor a better set of documents. You know, if you have a really good scope document that you never have to change, then there's not going to be any changes to that document and no compensation events. If you give the contractor, in this case, a really good set of site information documents, then this whole compensation event could have been avoided. So I don't think it's right to construe compensation events so negatively, because at the end of the day, they are simply client risks, and under the contract, they retain with the client, and it's up to the client to manage those at the pre-contract stage. So any final questions just on compensation events before we move on to payment, which we'll get through relatively quickly because it's dead easy. Paul, if you forecast on the compensation event that it takes 14 weeks and it's agreed, if it then takes 10 weeks, are you paid the actual cost or the forecasted cost? Forecasted cost, Paul, or sorry, Gordon. Sorry, it was Paul. Gordon jumped in after that. This works in the same way as we have before. So the 14 weeks in this scenario would be an extra 4 weeks at the end of this activity, and that becomes the accepted program. If the contractor then doesn't need that 4-week period, you know, the superstructure could start earlier, the commissioning could start earlier, and ultimately that 4 weeks will end up as part of this terminal float at the end, and that's the contractor's opportunity at that point. Risk and opportunity are two sides of the same coin. You know, if the contractor flips that coin and it lands on the risk side, then they have to bear the brunt of that. But if they flip that coin and it lands on the opportunity side, then there's no reason that they should not take the benefit, Paul. Which is why, if you're conscious of that happening, that's when you would start to use the PM assumptions to resolve that issue. Is it right to raise a high forecast to allow for higher target costs to allow for pay and gain? Yep, that can happen, Gordon, under an option C. So under an option C, the point of looking for a compensation event is it raises the target. So if that's your original target, when you have a compensation event, the target rises. And if you have over-egged the value of that compensation event, you know, it's only going to end up costing you this amount of money, then yes, you'd have a bigger gain share there. So it's always within the contractor's interest to inflate the cost of a compensation event. Doesn't matter if it's an option C or not, because under an option A, they're going to get more money. Under an option C, they're going to get more money plus more of the gain share. Deirdre, can a BOQ rate be used and agree actual quantities? So the starting point is that you do not use BOQ rates in any of this. Okay, I'll even jump back a few slides. You know, the clause that we're concerned with here is this one, 52.1. As you'll see here, it doesn't mention the BOQ, doesn't mention the activity schedule. You only use the rates and percentages in the contract data. But to be pragmatic, the NEC does have a clause that if it's a very straightforward compensation event, you don't want to go through all of this hoo-ha, then you can simply use any rate that you want. And that is clause 62.2, which says project manager and the contractor can agree to use rates or lump sums to assess the change to the prices. So you can agree any rate or lump sum you want, Deirdre, and the contract recommends that you do that, or the guidance notes recommends that you do that for simple compensation events. So marching on just to where we got to, and I'll answer that last question. Craig Smart, what if the activity was short and by the time the PM reviews the quote and the works were completed, it shows the contractor greatly overestimated his forecast? That's a very difficult question, Craig. There is a piece of case law which is called, again, it just so happens to be a Northern Irish case, but it's a UK wide, it's got implications UK wide. It's Northern Ireland Housing Executive, very litigious organisation in Northern Ireland, and Healthy Buildings. There was a series of those cases touched on different points, but one of the points that they touched on, Craig, is this one, which is what happens in that scenario where you get to the end of a project, the dividing date was 6 months ago and no one has actually assessed the compensation event. And what the judge decided in that case was you use the actual cost records. That was a High Court decision. Again, this is a High Court in Belfast. High court decisions you always take with a pinch of salt, because different high courts can arrive at different decisions. It's not until you get a court of appeal that says which one is right. This decision upset quite a lot of people in the NEC community because, quite frankly, it goes against what the contract says, Craig. So this is actually a very difficult subject to advise on. And the short answer is we're not going to know what the real answer is until we get another high court decision and the Court of Appeal clarifying it. All we can advise clients at the moment is to do what this case says, which is to use the actual cost records in that scenario. That sits at odds with me slightly because it is not what the contract says, but that is what you need to do at the moment, Craig, to give you a difficult answer to that difficult question. Graham, just before we move on then, with respect to the previous question, is there any cost amount or percentage that would warrant approval prior to commencing with the works? No, it's up to the parties to agree. If it's something dead easy, going back to Deirdre's point, if it's simply a case of you've got a very similar rate in the BOQ, it makes common sense to use it, then use it. But at the end of the day, if the contractor wants to go back to first principles, for example, if the BOQ rate is rubbish for them, they might want to force the hand of the PM, then they're perfectly entitled to do that, because both parties have to agree, Graham, for that clause to operate, and that agreement does not have to be forthcoming. So payment then, as I say, we'll get through this relatively quickly because at the end of the day, there's only so much you can do with a payment clause in the UK and in the Republic of Ireland as well, because the laws prohibit us from changing it dramatically. So there's two parts to this. Clause 50 sets out how you work out the value of the work. That links back to what we talked about in our first lecture, depends on the main option. So you might remember that we talked about before, you have these different monthly intervals. If it's an option A, it's all about completed activities in a given month. If it's an option B, then it's a bit more generous because you work out the quantity of work. And if it's an option C, it's totally different. It's all about forecasting and whatnot. So that's what clause 50 sets out. How do you work out how much you're going to pay the contractor? If they're in delay, it also sets out, how you take off the liquidated damages, etc. That works out how much the contractor's paid. 51 then dovetails with that, and that sets out when you pay them, and it's as straightforward as that. It sets out the time frames, sets out how you work out those monthly intervals, the assessment dates, sets out when the last assessment date is, and ultimately that triggers all of the dates that you need to put into your diary. Clause 52, this one sits in a bit of a weird place, to be honest with you. It's primarily used for compensation events under option A and B. Under the other options, it's used in a bit more of a robust way to do with payment, but we've already talked about clause 52 this evening, and we looked at it with reference to 52.1 and having to use the contract data to work out the value of compensation events, etc. This final clause is worth noting because this is something that is new under NEC4, okay? And it is the final assessment mechanism. And I'll touch on it in the second slide after this, but it's effectively a final account. So NEC4 has a final account, NEC3 doesn't, just something to be aware of. The final two things just on this slide, you do have to use secondary option YUK2 if you're working in the UK. So by using that clause, it just updates all of the terminology to make it compliant with the Housing Grants Act. The structure of it is exactly the same, but they change some of the words around slightly just to make it act compliant, because the NEC, strictly speaking, is an international contract. It's not UK specific. So to make it UK specific, you have to use that clause. And as I said before, if you are in Northern Ireland, that should say Y, not U for some reason, then you have to use YNI, which, as I said before, will be published in the next couple of weeks. So stay tuned for that. So as I said, clause 50 sets out how you pay the contractor effectively, or what you pay the contractor. And as I've just said, it very much depends on what main option you're using. So for example, price of work done to date under an option A is all of the completed activities. Under option B, it's the quantity of work done, etc. Plus other amounts due to the contractor. So this is when you have to start looking at some of the secondary options that you've used. So for example, if you have option X6, which is a bonus for early completion, that's where you'd pay it. If you have option X21, KPIs, positive KPIs, where they get money for doing something extra, then again, you would pay them under that second bullet point, dead easy. The other one is a deduction, and that's the likes of liquidated damages. So X7, for example, contractor is in delay. That's where you can retain those delay damages until such time that they complete the job. And then you have a big fight about it normally. Or another one would be X16, retention. Again, we talked about all these secondary options before, but that's where you would make the deduction. So moving swiftly on then, just to look at the, well, this is, sorry, incorrectly stated here. This is clause 51, that should say, and this is all about interim assessment. We made that slide in a bit of a rush. So what we're looking at here is just the payments as we go along. It's not very complicated, so we'll get through it rather quickly. So the starting point in establishing this mechanism and all the dates that, you know, set out when the contractor has to be paid by, when the PM has to issue their certificates, when the pay less notices have to be served, etc., all start at the starting date. And as you can see there, the starting date is an identified term. So it means you go to the contract data and it will tell you what the starting date is. It's the starting point, and it will then drive when the first assessment date takes place. And it is up to the PM to decide when that assessment date takes place. What the contract says is the PM decides the date to suit the procedures of both parties. So if the contractor, for whatever reason, likes to be paid at month end, you know, you would set up the assessment date to facilitate that. Or if the client needs to make payments on certain dates, you can have the PM set up the system to facilitate that. It's just designed to give the parties a bit of flexibility. The only constraint or limitation that you have is that that first date has to be no longer than the assessment interval after the starting date. So let's say that's monthly. The first assessment date has to be at least within that first month. Can't be after that. The PM has to put it somewhere in month one. It's not very complicated, so don't, you know, stress out on that point. Once you then have determined the first assessment date, all of the others roll on a periodic basis at the assessment interval thereafter. So if you've decided that your assessment interval is monthly, your first assessment date is the 18th of the month, then your next assessment date will be 18th of the month thereafter. And that just keeps going and going and going all the way up until the end of the project, and whenever the defect certificate is issued. Slight difference between NEC3 and NEC4 there. Under NEC3, there was an extra assessment date at completion. I'm acting as an adjudicator at the moment on a dispute over that very point and what happens in that scenario, but we'll not get into that in too much detail, other than noting that clause is actually different under NEC4, and they actually go all the way up to the defects date, and there's no additional assessment date at completion. But aside from that, it's just rolls on a periodic basis. In terms of the payment system itself then, so it all starts with the contractor providing an application for payment. And one thing to note there, this is also new under NEC4. Under NEC3, the contractor did not have to give an application for payment. Sounds a bit odd, but they didn't have to. It was up to the PM, regardless of whether or not an application was served, to certify payment every month. The contract allowed a contractor to make an application for payment, but it didn't require them to. And that's different under NEC4, where the contractor is now required to submit that application every month. People were doing it anyway. It's no real difference, but one worth noting for us academics. Thereafter, you have this same little procedure every month where within 7 days of the assessment date, the PM is required to certify how much the contractor is to be paid. Again, looking at the previous slide, that sets out how you work out the calculation, and they have to issue a certificate within 7 days of each assessment date to tell the contractor what they're getting. The amount set out in that certificate then has to be paid within 14 days. So all in all, under the NEC4 as standard, unamended, it's 21-day payment terms. You are free to amend that if you want. You can go in and you can extend that 14-day period to 28 days, which would be quite common, 35 days, whatever it happens to be. So you are allowed to elongate those payment time frames if you so wish. And the final thing that you can do as the person making the payment is issue a pay less notice, which I'm sure most people in the audience have heard of, which is effectively a notification to say, I'd agreed to pay you, well, let's say I asked for 100K here, I assessed it at 80K here, but based on this new information that's come to light, I'm now only going to pay you 60K. Again, that's what a pay less notice is for, to pay less than the notified sum. This little structure that you can see, this happens every month. So again, every assessment date should have a little system that looks exactly like that. And that little structure is what the law says it has to look like here in the UK. If you're in Ireland, it's slightly different. If you're in Northern Ireland, it's exactly the same, albeit some of the terminology is slightly different, but structurally it's exactly the same. Are there any questions just on that? Just conscious of the time. We've got a couple of slides to get through. Any questions on payment? All dead easy. Again, a couple of points on NEC3, NEC4. This is different. This is different. But aside from that, it's the exact same that you'd be used to. This is brand new under NEC4, however, there was nothing like this under NEC3. And this is a final account mechanism. And what it basically sets out is within 4 weeks of the defect certificate. So we're not talking about completion here or practical completion, if you want to call it that. Within 4 weeks of the defect cert, which is normally a year or potentially 2 years after the job is done, you have to go through this final account process. And what it requires is the PM, again, to issue an assessment within 4 weeks of the defect cert to set out how much the contractor is going to be paid. And if there is any further amount due, again, potentially the final release of retention would be due at this point. That has to be paid to the contractor within 3 weeks. Word of warning. I'm going to make a big point of, there's the dyslexia creeping in. See, trying to write and speak at the same time, not easy. And I'm going to make a big deal about this because under clause 50.3, if you are not happy with the PM's assessment, contractors in the audience, you have to challenge it. Okay, you have to challenge it within 4 weeks. Under the unamended contract, it's 4 weeks. If you don't challenge the final account within 4 weeks, you lose the ability to challenge it thereafter. It becomes conclusive evidence of what your entitlement is. And that's a big thing to be aware of. Didn't exist under NEC3. There is a big, big line in the sand. PM assessment at the end, challenge it within 4 weeks, or you lose the ability forever after to challenge it. Can't go to adjudication, can't go to court, can't go to arbitration, gone. So that's the warning, and you have been warned and you have been told. Any questions on that? That's designed to, draw a line under the project. Most other contracts have something similar. JCT clause 1.8 has the same thing. So yeah, no different to the industry norm. Final topic then of the course, which again we'll get through relatively quickly because it is a short one, is correcting defects and managing defects. The only real difference here, as I said at the start, between the NEC and most other forms is the fact that the NEC has a very prescribed period in which defects have to be corrected. And we call that the defects correction period. As you'll see there, it's in italics, and that means you'll see the definition or what the term means within the contract data. So for example, the client might say that it is 2 weeks. And they've also got the option to put in different time frames. So they might say if it's a defect to do with the heating system, it's only 1 day or 2 days. And they're free to do that within the contract data. As you can see here, when that period starts depends on the type of defect that you're talking about and when it was notified. So for defects that are notified before the job is finished, they have to be corrected within the defects correction period after completion. So think of those as your snags. So you walk the job, you're able to complete the work, but there's a long list of things that need to be corrected. They have to be corrected within that defects correction period from the date of completion itself. Again, from the defect certificate, effectively, if it's issued on time. If further defects arise after completion, something's been discovered that wasn't on the original snag list, then the time frame starts the date that the defect is notified. So again, there's no waiting about for a further snag list. As soon as it's notified, you get it corrected. And the final thing is, when does this defects correction mechanism end? It ends at one of these 3 dates, either X amount of years after completion, so normally 1 year after completion, or 2, or alternatively, if you've notified a defect, just before that line in the sand, then you've got this defects correction period stretching beyond it. It'll be at the end of that defects correction period, or whenever the defect is eventually corrected. So not that complicated, really. It's a lot more prescriptive, I would say, than most other forms of contract, but at its core, it's the same as most. So the final slide here just on defects is all about defects correction. So you've identified a defect at this point, and what we're looking at is the 3 different options that you have to deal with it. So number 1 is to accept it. So if everybody is happy with the defects, the wall has been painted the wrong color, but you know what? The employer quite likes the color that it's been painted. You might just want to accept it. You don't make the contractor go and correct something if you don't want them to. The contract has a mechanism for dealing with that. If, say, the paint that the contractor used across this massive housing scheme was £2 or £3 a litre cheaper, then that saving would have to be offered back to the client in that scenario, which again is the quid pro quo of the contractor having that defect accepted. They don't have to go back and correct it, but they have to offer back the saving as a result, which I think is a fair way to deal with that. The other 2 things which you can do with uncorrected defects depends on whether or not you gave the contractor the opportunity to come back and fix it. So if you gave the contractor fair opportunity to come back and correct the incorrectly painted wall, but they simply didn't do it, then you can correct it yourself and charge the contractor for it. So you can bring in another painter and you can assess the cost of how much you paid that other painter, and the contractor has to pay you for that. You're probably in a dispute at that point. You're going to have to chase them for the money, but in theory, you're totally able to do that under the NEC. The other scenario is when you didn't give the contractor fair opportunity to come back. The premise is exactly the same. You can still have it corrected by other people. It's still a defect. It still needs to be fixed. The only slight difference is when it comes to the assessment. You have to assess it as if the contractor came back themselves to fix it, which naturally would be a slightly lower amount of money and that wouldn't have the profit margin on it that bringing in someone else would. And perhaps the contractor, would be able to do it much more efficiently than someone else. And that's the only real difference there. Practically speaking, it's not going to be a massive difference realistically and speaking from experience. So we're bang on 8:30. This is our penultimate slide, just to talk a little bit about how the NEC3 is different to NEC4. What I'm going to do, as I said at the start, I'm going to circulate a memo, which I've pictured there, that I provided to all of my clients in, it seems to be the middle of last year, which sets out in quite some detail the differences between these contracts. As you'll see when you read that document, again, I've just bullet pointed it out in nice simple English, easy to read format. The differences are not massive. It's more evolution of the contract opposed to dramatically changing it. Changes in terminologies, the ability for the contractor to issue proposals to change the scope, proposals to accelerate, slightly different. We talked about that requirement for payment applications earlier, and the final account mechanism is different. This whole mechanism of working out the defined cost of a compensation event, that's a big difference in my opinion. They've taken away lots of the silly little percentages that you had to apply under NEC3. It's all now under the 1 fee percentage, which makes it an awful lot easier. And the final thing that I have also listed in this memo is a list of hyperlinks to the NEC website, where you can download all of the post-2017 amendments. So this contract was published in 2017. There's been a number of developments in the case law since then, and the NEC has published on their website, free to download, some amendments to the contract, and I've signposted you towards that. But aside from that, that is us. I'd just like to thank everybody for staying with us over the last couple of weeks. I provided there a QR code to a feedback link. And I've also just put into the chat box a hyperlink to that. So if you'd like just to maybe provide some feedback for ourselves and Engineers Ireland, that would be lovely. And if you do fill in the feedback form, there is a place available on the NEC course that we're running starting in September of 2023. It's a 24-week course. So again, if you fill in the feedback form, you'll be in the mix to get onto that course free of charge. And if you can't go, you can pass it on to a colleague. And finally, just thanks, Philip, and your colleagues at Engineers Ireland for having me. And hopefully I'll see you again in a year or two's time.